Tommy Broughan, 10 minutes.
I'm also delighted to welcome this bill. I mean, it's been an astonishing long time in gestation, Minister. I think you can go back to the Commission on Judicial Conduct and Ethics. I think in December 2000 advised that the Judicial Council be established. So we're going back, in fact, 2 decades here. And that's the problem, I think, about judges in the court service. Things seem to move at a glacial pace. It's striking, of course, that Chief Justice Clark, he has asked for more resources, Minister. More support resources in relation to training of judges, resources at all levels, indeed, of the court service. And as you know, I've asked many questions here over the years in relation to road safety in particular, and the lack of efficiency in relation to the production of records, which An Garda Síochána need, which the RSA need, and so on. So I think it's amazing that it has taken so long. Now, I know we've had Minister Dermot Ahern published, was it the first heads around 2010, that's a decade ago, and of course we've had the interim Judicial Council over the years from 2012, and I think the aims of that set out then by our judges were excellence in exercising judicial functions, the efficient use of resources, continuing education. That's such an important point because it's astonishing again that it took us till today to establish a system of lifelong education for judges. Now, in O'Cahirlock, you could say perhaps TDs need the same, ministers need the same kind of in-service training continually, but it's really important in relation as society changes, particularly in relation to judges. So I think that the draft bill of 2010, and again it's nearly a decade ago, included the first provisions for conduct and ethics, and for the public who were very upset perhaps at particularly lenient sentences in outrageous cases, or at general conduct of a few judges, that they couldn't make this complaint. But having said all of that, obviously having an independent, a strong, well-resourced independent judiciary, it's a hallmark of democracy. And I note that the measuring tape, if you like, for all countries' judicial systems, were one of the ones that I remember referring to on a number of occasions, of course, are the Bangalore Principles of Judicial Conduct, which were drafted, I think, by the UN General Assembly, the Human Rights Commission in 2003. And of course, the values, the 6 values, core values that we expect in our judiciary, of course, independence, integrity, propriety, equality, competence, diligence, and practicality. These are the kind of values that we need to see running right throughout the judicial system. Our own excellent library and research service, as always, presented us with a very good background paper. I know there have been the amendments since then, I think, Minister, but it's interesting to look at systems, the Judicial Council, for example, of England and Wales, the Canadian Council, which oversees, I think, about 1,100 judges, with a 39-member council, not unlike the bill before us. Not all the judges are members. The Council of New South Wales, and indeed the United States, it has to be said, where, of course, Minister, one area that we have never looked at, but people might say if we were to become a true democracy, we should do, is the election of some judges, which is characteristic of parts of the American system. But they've had the Americans, of course, have had the judicial ethics model since 1924, so shortly after the foundation of our state. Well, many people would think, Minister, that such a senior role in the state might be a role that all the people might make a decision on. I've often felt the same about the Governor of the Central Bank, for example. We saw just in the last few days the 4 of the highest positions in the European Union decided by, backroom deals, as I think MEP Matt Carty said yesterday. Maybe there is scope for a more democratic system still. I note that we're superseding here sections 10 and 36 of the Court Provisions Act 1961, which allowed, I think, the Chief Justice Justice to investigate the administration of justice at the district court level, and also, of course, in the later bill, I think the Court and Court Offences Act provided some funding for the training of judges, but it didn't really lay out any fundamental improvements in that regard. I do believe still we need the improvements today. Obviously, the Council itself, the committees on the whole complaints procedure, which takes up, I think, the bulk of the bill, the committees on conduct, on training, and so on. They're all very, very valuable and important improvements. But I think many citizens feel, Minister, that we need a more fundamental reform. For example, why should professional guilds like the Law Society and King's Inn have a fundamental role in and control over the education and apprenticeships into the legal system? I mean, why aren't the university, as most professions, why aren't the university law departments at the very centre of the training, not just indeed probably of lawyers generally, but of judges? I mean, why hasn't that been considered? I think judges need to be representatives of society, and that's something, again, because again there tends to be a sort of a self-perpetuating legal elite. In fact, you can see it through some families down through the decades, which goes on and on and on. And we need to have a broader based, and I do welcome, of course, Minister, that I think over the last number of years that there's been gender equality at long last in the solicitor's profession. But personally, I would favour, of course, just a single profession of a lawyer. This archaic English system of barristers and solicitors is something that should be on our agenda. So I still think a future government, we need very fundamental reform of this system. Having said that, my own experience, and like pretty well all of us, we've been in court with different local issues and with, representing people and so on, or helping to support them. And I have to say that, of course, in cases I've been aware of, obviously like the Flood Mahon Tribunal, the Moriarty Tribunal, the Priory Hall case, for example, judges' performance has been courageous and exemplary. And I have to say also, it's also a pleasure very often to have read the reports that have been carried out by members of our judiciary, the Morris Tribunal report, for example, the Charlton report, very fluent, to the point, and important reports for this House. So, we have gratitude, obviously, for our judiciary in that regard. Also, I was in correspondence, Minister, with the Chief Justice. I think I probably asked you about that in relation to legislation, whether or not our own House, the Chief Justice was saying, I think, at one seminar, that we should try to avoid bringing in legislation which will be litigious, and to have a litigation stress test, in fact, for all legislation, which was also important. And I know Chief Justice Frank Clarkey has expressed a number of ideas, like having a more regional development in the lower courts to allow specialisation by judges, and also, that obviously judicial training, addressing the Book of Quantum, and in relation to insurance costs and so on. Actually, one of the interesting points that the Chief Justice made was in relation, Minister, in relation to records of evidence and the records of courts. He was saying that, except in, I think, indictable cases, the records are simply not there, or they're very little there. So I think that's an area also where we need to look at. But I mean, looking through the bill, as colleagues have said, I think the one other point I'd like to mention, I mean, you're on the negative side, your colleague, I think, Minister Ross, asked, I think, at one cabinet meeting, was it recently, that we should have a declaration of interest in this. I mean, our interests are known, Cathaoirleach. Everybody knows in this House, what business interests, who's directors, who are landlords, who are farmers, who are teachers, or whatever. And again, I think that proposal from Minister Ross was a reasonable proposal, and is something that should have been considered, will have to be considered, because we should know the interests of people carrying out such a fundamental role. It's also very disappointing, of course, with the filibuster that's been carried out in the other House in relation to the Judicial Appointments Bill, which again I think reflected all the worst elements of an elite legal legal class determined to prevent encroachment onto their kind of sacred turfs. But as I said, people also mention, of course, about sitting times, about the length of the day for judicial. We hear, I mean, if people are going to say to us next week, of course, you're all off on your holidays. And of course we know that we're going off into intense, like Mr Éireann used to do in this House. He used to immediately change into maybe 2 months long, door to door in Dublin Central. And of course we'll all be out and about because we know general elections not too far away. We always would be anyway. And of course we get a chance really maybe to, what we'd say, to do real representative work, you know, outside the chamber. But the hours of work, but the supports that judges have, which the Chief Justice has commented on, the additional resources are important. But people often feel, Minister, that you know, the closure of the system, I think, for August, September is regrettable. But with those kind of caveats, I do welcome it, and I commend the Minister for the work that he's done with colleagues to finally bring this bill before us. I think it is a good step forward. Thanks.